Hello, this is day 21 of the 30-day challenge for 30 days of appellate tips. Today we're going to talk about filing motions in the Court of Appeals. The rule governing motions is MCR 7.211. Now in that rule there are several different kinds of special motions that are addressed, but there really is no limit to the types of motions that can be filed. It's really only limited by the creativity and imagination of an attorney who is looking for some sort of relief in the Court of Appeals. Obviously, it has to be some sort of relief that can be offered by the Court of Appeals. But if you are filing a special motion, such as a motion for peremptory reversal, a motion to affirm, a motion for a vexatious proceeding, whatever the case may be, you have to make sure you follow the very specific requirements that are provided by the court rules for those motions. But for any other kind of motion, you just generally come up with the type of motion asking for the relief that you want. There's some generic rules governing motions, and the response times. It's really important to remember that when you receive a motion, there are about 5 or 6 different response times in the Court of Appeals depending on the type of motion it is. So you want to always make sure you check the court rules carefully to see how much time you do have to respond to the other side's motion. But and also if you need to have a motion decided quickly, you have to file a second motion called a motion for immediate consideration if you need a decision more quickly than what is governed by the court rules. So there's a few things to remember with filing motions. Our practice is we file motions all the time. We're constantly filing motions. A lot of them are emergency motions, and the Court of Appeals is really good about ruling on the motions expeditiously when the case requires. The other thing is the filing fees. Just keep in mind that every motion costs $100, but if you have to do a motion for immediate consideration, that is an additional $200. So the fees can add up pretty quickly when you're filing motions, if there's a lot of different motions that need to be filed in a case. So make sure your client is aware of that before you start going crazy with the filing. And the last thing to remember is that there's never argument on the motions. It's not like a trial court hearing. The Court of Appeals decides the motions based on the paperwork that's provided to the court. So there you go. That's a little bit different than the trial court. Thank you.